having an instrument of title is no sufficient proof of ownership, where the registered proprietor's root of title is under challenge. If the original allocation of land is unlawful or irregular, the entire chain of ownership is vitiated, even where the current holder is a bona fide purchaser for valid. Scrutinizing the documented history of ownership is now a necessity for every conveyancing transaction. So you go ahead to scrutinize the green cards of the land registry. You go all the way to when the land was registered, so that you establish the movement of ownership of that land. Then that is again now a person now to do diligence and such, do diligence of an advocate and such. Then we have question 2 on Torino enterprises. So we will discuss this more. I just gave a brief because I will discuss this more when we are doing conveyancing project work. I think that will be tomorrow, Victor.
Yes, tomorrow is for project works.
We will go deep down into dinner management. So let me proceed. Torino Enterprises Limited versus the Attorney General. A letter of allotment does not confer a transferable title on the allotee. An allotment letter is merely an invitation to treat and does not constitute a contract or confer any transferable interest in land. An allotee who has fulfilled all the conditions of an allotment letter but has not registered the land in their name cannot pass a valid title to that party. The Commissioner of Lands may also lack authority to allocate land that has been converted from government to private freehold. Conveyancers must insist on registered proprietorship before concluding any transactions. So for Torino, it is on the letter of allotment. A letter of allotment is just an invitation to treat, and it does not constitute a contract or any transferable interest in land. Then we have Harcharan Singh Semi and another versus Tarabana Company Limited. This is a good one. This is a good one. Victor, you have sent a one pager on this. I wish to present using that one pager, if you'll allow me, members. Let me present this case using a one pager that Victor had sent. In this same case, I found it very interesting actually. Very interesting case about renewal of leases, let's see it. It's a very interesting case. About renewal of leases and something. Let's see. Let me just open very fast. Here is the one pager that Victor had given us. So let me share this pager. So here's the one pager that Victor sent. It is in the group. So it is a one pager summarized by Yakeo Murray, the advocate. What the Supreme Court said in the same case. The Supreme Court of Kenya settled this question in Harcharan Singh Semi versus another versus Tarabana Company Limited and 5 others. The court plainly stated that once a lease expires and no extension has been formally processed, the land reverts to the government. By the time the suit land was allocated to the second restaurant, the lease had long expired. It was no longer a leasehold estate, but government land. So if your lease expires, the land reverts back to the government. The Semi family learned this the hard way. They bought a 59-year lease of a property in Ringera, Nairobi in 1968. The lease was due to expire on 1st October 2001. On 13 July 2001, in less than 3 months before the expiry, they applied for what they called a renewal. The Commission of Lands wrote to the Director of Physical Planning and the Director of Survey seeking objections. Both responded, no objection. Then nothing happened for 8 years. So the government never told SEMI whether the application was approved or denied. The SEMI stayed on the property paying rates and rent. In 2009, without any communication to the SEMIs, the government allocated the land to Rospatek Limited. The allocation was signed by a land officer, no the Commission of Lands, no public auction was held, no gazettement occurred. Rospatek sold the property to Taraban Company Limited. Tarabana took a loan of 61 million from Prime Bank and built an 8-story commercial building. And in October 2014, forcibly evicted the SEMIs. The Supreme Court found that because the SEMIs had applied before expiry and the government acknowledged the application, they had a legitimate expectation that their lease would be extended. But the court also made clear that the application was for extension, not renewal. They acted before expiry, that distinction mattered. So now back to the presentation. So the SEMIs had applied for an extension of the lease and not a renewal. That's what the court said. Back to presentation. I will just go for it once again. The SEMI family held a 59 years lease of a land in Ringera, Nairobi, acquired in 1968 due to expire on October 1, 2001. On 13 July 2001, less than 3 months before expiry, they applied for renewal. The Commission of Land sought responses from the Director of Physical Planning and Director of Survey. Both raised no objection. Nothing then happened for 8 years. In 2009, the land was allocated to Rospatek Limited by a land officer, not the Commission of Lands, the public action or gazettement. Rospatek sold to Tarabana, which borrowed 61 million from Prime Bank, built an 8-story commercial building and forcibly evicted the SEMIs in October 2014. The Supreme Court held once a lease expires without formal extension, land reverts to the government. The SEMIs had a legitimate expectation of lease renewal, having applied before expiry and received acknowledgement. In 2009, the 2009 allocation was unlawful, executed by the wrong officer without following the due process. An illegally acquired title cannot defeat prior legitimate interest, even where acquired in apparent good faith. The appeal was allowed, titles cancelled, and the SEMIs restated as proprietors. The title deeds were prima facie evidence of ownership and not conclusive proof. So I hope you've seen about the SEMIs. I hope you've just gotten what the SEMIs case was about and what the court held. I will share this page so that you have a look at it again. And also maybe you can just check the case in this page. Go download the case on Kenya Law Reports and you can go through the same again. So I have another case, MAS Construction Limited versus Sheikh. The Court of Appeal held that the Commission of Lands lacked power to reallocate land where a lease has expired if that land had already been alienated. New leases cannot be issued on government land that has been previously been subject of lawful allocation. Conveyancers must verify states specific legal capacity to allocate at the exact moment of allocation. I have another that is Teleposta Pension Scheme versus Intercountry Exporters Limited. Irregular grants of land are avoided at the issue. An irregular allocation results in a title that is void from the outset. It cannot be used to transfer interest or to serve as security for a charge. This underscores that conveyancing is no longer a mere procedural checklist exercise, but requires substantive inquiry into legality of the root of title through the ownership chain. Conveyancing implications, that is the name non-habit, you cannot give what you do not have, applies even to bona fide purchasers for value where the root of title was unlawfully acquired. Land Registration Act 2012, Section 24 to 26. Indefeasibility of title is not an absolute overriding, is not absolute. Overriding interest and unlawful acquisition initiate the register. I hope you will have a look at the Land Registration Act, Section 31 and 32, or thereabout, about overriding interest. This overriding interest, they can override a title to land. Conveyancer's duty. The advocate acting in a conveyancing transaction must advise the client on route of title investigation, including official searches, historical ownership records, and legal basis of original allocation. Article 40 Constitution. A right to property does not protect irregularly acquired land. Then we are now at 5. We have a probate dilemma with us. In real estate of Samuel Kamau Wanjiro, background. This is the estate of the late Samuel Kamau Wanjiro, the Olympic marathon champion. I remember Samuel Kamau Wanjiro, he died, he was thrown off a balcony or something, or he jumped off a balcony.
Yes, allegedly he fall, allegedly alipushiwa.
Yes, that's much. So the matter concerns an application by Judy Wamboi Gishuki, alias Judy Wamboi Kamau, the applicant, against the two administrators of the estate, Teresia Njeri Kamau, first administrator, and Margaret Wangeshi Muturi, second administrator. The applicant sought revocation of the letters of administration granted to the respondents and subsequently confirmed on 30th October 2018 on basis that the proceedings were defective, specifically that a child born after the death of the deceased was not considered in the administration. The court holdings, on any evidence on paternity, the subject child has been proven to be the son of the deceased and has full entitlement to benefit from the estate. The evidence established paternity notwithstanding that the child was born after the death of the deceased. Nasitara's principle, that is Nasitara's fiction. The court applied the Nasitara's principle: a child conceived but not yet born acquires the rights enjoyed by other children alive when those rights arose if subsequently born alive. This is codified in section 3.2 and 3 of the Law of Succession Act. Victor, you can speak to us on this if you have anything on this Nasitara's fiction principle.
A child not yet born acquires rights enjoyed by other children alive when those rights arose if subsequently born alive. This is codified in section 3.2. So in other words, this is called the posthumous. Let me type it out. It is referred to a posthumous child. If you search posthumous child definition, is a child who is still in the womb. So a posthumous child is an infant born after the death of one or both of their biological parents. Most commonly, the term refers to a baby born after the father passes away while the mother is still pregnant, but it can also apply to a child delivered after the mother's death. So in Kenya, we have various interpretations. When we had Kenya Law Report, where there was a decision where the judge had to say that that man was a posthumous. According to Section 3 of the Law Succession Act, the definition of a child expressly includes a child conceived but not yet born, provided the child is born alive. They have full inheritance rights and are treated equally as other children. Conceived posthumous, generally excluded. Kenyan courts have consistently ruled that children born or conceived years after a husband's passing, even by the widow, cannot be regarded as dependents, nor are they entitled to inherit the deceased estate unless specifically provided for in the will. So remember, there is a gestation rule. In cases like Milka Wanjiku versus Rose Wangeshi, the judiciary firmly established that children born more than 9 months after the husband demise do not fall under Section 29 of the Act and cannot lay claim to the property. And we also have, lastly, children born out of wedlock. If a posthumous child was born out of wedlock but conceived prior to the father's death, the child must be explicitly acknowledged or accepted by the father during his lifetime to inherit. Following a landmark Supreme Court ruling, petition number E035 of 2023, children born out of marriage have equal inheritance rights to those born within it, provided paternity is proven or acknowledged by the deceased. So there was a landmark decision to that effect, and I've decided to explain various angles that that formed the basis of it. So the decision yenye imeniletea inani link to the court's finding. The Supreme Court affirms inheritance rights of children born out of wedlock in Muslim succession cases. The case of Fatuma Athman Abud Faraj versus Ruth Faith Mawasi, 2024. And the key takeaway was that, where is the conclusion? Basically, they recognize children born out of wedlock and their paternity is not in dispute. All children fathered and acknowledged by the deceased were declared beneficiaries or dependents, with the exception of one whose paternity was disproved. Okay. Equality trumps blanket discrimination. While Article 24(4) permits the application of Muslim law, the court found that this cannot be used to justify blanket discrimination against children born out of wedlock. Any such departure must meet a strictly necessary proportionality test, which the applicant failed to demonstrate. So basically, inakuonyesha that even a posthumous child will be subjected to that scrutiny. That is what I could have added to that mysterious fiction.
So,
Yeah.
in addition to that, it has raised some things about about what the court considers when granting to dependents. Okay, let me rephrase this. What considerations that the court take into account when trying to ascertain whether a certain claimant to an estate is a dependent. So I want to present that case of Samuel Ongiro. I just want to present some few paragraphs, then I will just look at it later. So in this case, yes. So you can see here, this person. Okay, I don't know. Let me see where to start. Okay, I won't go so much into the case. But I'll just try to see the defendants. So let's start here at where the court says Section 28 of the Law of Succession Act provides circumstances to be considered by the court in making order, in considering whether any order should be made under this part, and if so, what order the court shall have to regard to: A, the nature and amount of the deceased property, any past, present, or future capital or income from any source of the dependent, the existing and future means and the needs of the dependent, whether the deceased had made any advancement or other gift to the dependent during his lifetime, the conduct of the dependent in relation to the deceased, the situation and the circumstances of the deceased, other dependents, and the beneficiaries under any will, the general circumstances of the case, including so far as can be ascertained, the testator's reasons for not making provision for the dependent. Because now, this part G is very important, because it might be that the deceased person did not want at all to make provision for this particular dependent. So the court has to assess all these factors so that they determine whether a person is a dependent and what order the court can make on that. Then Section 29 unpackages the meaning of dependent for the purposes of this part. Dependent means the wife or wives or former wife or wives and the children of the deceased, whether or not maintained by the deceased immediately prior to his death. Such of the deceased parents, step-parents, grandparents, grandchildren, stepchildren, children whom the deceased had taken into his family as his own brothers and sisters, and half brothers and half sisters, as were being maintained by the deceased immediately prior to his death. Whether the deceased was a woman, her husband, if he was being maintained by her immediately prior to the date of her death. Without spending too much ink, the applicant who alleges must prove, by providing evidence in this instance, its finding that the following facts remains allegations without proof. So the court in this case he may fail to find he may fail to find for the applicant. That in the year 2007, the deceased did visit her guardian. Now this is Lea Mudhoni Kerile, her guardian's home, and proposed to marry her, and her guardian agreed to save her. Agreed, save that her guardian proposed that she should first complete her college studies. And between the year 2007 and 2009, she was in college at Tracom College, and it is the deceased who paid her college fees with the full knowledge of her guardian. That since 2009, when she cleared college to the time of death of the deceased, they were living with the deceased as husband and wife. That they lived in a house in Nakuru, which was furnished by the deceased. That when the deceased died, she took part in the funeral arrangements. That the deceased made to know his mother, Anna Wanjiro Kamau, about their marriage, as she would often reach out to her. That before the demise of the deceased, she and her unborn child depended on him for their daily upkeep. So huyu unborn child ndo tunaongelea the Nasistaras principle. The court is unable to find that the applicant falls within Section 29 of the Law of Succession Act as a dependent to the deceased estate, in however as much as she might have been in a romantic relationship with the deceased, as she exhibited in the 2 paragraphs released in evidence, she thus had no standing as such, and her pleas are rejected. However, Nasitaras is one of the most well-known legal fictions that exist in justice, especially in inheritance law. It basically means that should a child in womb be born alive, then such a child acquires rights enjoyed by any other children who were alive at the time such rights arose. The Nasitara's fiction is a legal principle ingrained in the Law of Succession Act, Section 3, 2, and 3 of the law of that act, and provides the interpretive context of a child as follows. References in this act to child or children shall include a child conceived but not yet born, as long as that child is subsequently born alive. And in relation to a female person, any child born out of her wedlock, any child born to her out of wedlock, and in relation to any male person, or any child who he has expressly recognized or in fact accepted as a child of his own, or for whom he has voluntarily assumed permanent responsibility. 3. A child born to a female person out of wedlock, and a child as defined by the subsection 2 as the child of a male person, shall have relationship to other persons through her or him, as though the child had been born to her or him in wedlock. So you will go back to this section with me, and Sitara's principle as has been covered. So let me go back to the presentation. So we have seen that in the case of Samuel Wanjiro, his wife, now I use wife in quotes because now the court determined that she was not a wife. She was just they were just in a romantic relationship. So she was disinherited by the court, but the child was recognized by the court pursuant to the Nasitara's principle. So the court failed to recognize her as a dependent, but pursuant to the Nasitara's principle, the court has identified that the child is a dependent. So section 3.2 refers to child to include child conceived but not yet born if subsequently born alive in relation to a male person, any child whom he has expressly recognized or in fact accepted, or for him he has voluntarily assumed parental responsibility. The administrators were responsible for identifying all legal claimants, including children born out of wedlock, spouses in polygamous unions. This is part of the due diligence expected before confirmation of a grant. An administrator cannot feign ignorance. The court found it was cautious and deliberate on the respondent's part not to establish the subject's entitlement. Article 53 the best interests of the child constitute an enforceable right and merely a guiding principle applicable both in criminal and civil matters. Grounds for revocation of grant. Section 76 of the Law Succession Act, the court identified 3 grounds for revocation. The grant was improperly obtained by fraud, misrepresentation, or concealment of material facts, including where entitled persons were not disclosed. 2, where the grant was procedurally obtained but administration had been conducted improperly. And where the grant has become useless or inoperative. In this case, the court found that the grant was fatally flawed. The respondents withheld knowledge of the subject's existence from the court to obtain the grant and its confirmation. So, categories of competing claimants in probate. There is the wife under Section 3.5. Definition of wife includes a woman married under any system of law creating competing claims in polygamous and customary marriages. Cohabitees may claim under the family provision jurisdiction, no automatic right, but the court has discretion. A divorced wife loses spousal rights and dissolution of marriage may retain maintenance rights whereas subsisting court order exists. So a divorced wife loses spousal rights on dissolution. But if on that dissolution of the marriage there was a court order on maintenance, what do we call it? Alimony. It's called alimony payments. If the deceased person was making alimony payments to a divorced wife, then she remains. Children born out of wedlock. Section 29 of the Law Succession Act entitled to share in the estate of their parents. 10 directly engages this provision enforced by Section 3.2. Adopted children, same rights as biological children under the Children's Act 2022. Victor, we have gone through this actually. This part of adopted children and children born out of wedlock. Now, today we have seen something else. We have seen Nasitara's principle. Children not yet born, that is the Nasitara's principle, as now has been brought out in this case. So the reasonable provision is the court's equitable discretion to vary distribution to meet dependents' needs. The elastic provision is under Section 26. And then we go to the 2/3 gender rule and the Maraga advisory in 2021. So I hope you're all there before I proceed to issue 6. We're all there?
Yes.
Okay. My presentation is visible? Oh yeah, yes it is. Okay. Constitutional basis. Article 27(3) of the Constitution provides that women and men have the right to equal treatment, including the right to equal opportunities in political, economic, cultural, and social spheres. Article 81(b) requires that no more than 2/3 of the members of elective public bodies shall be of the same gender. Article 100 requires Parliament to enact legislation to promote representation of women, persons with disabilities, youth, ethnic minorities, and marginalized communities. So in 2020, Maraga gave an advisory to the president. He actually recommended the dissolution of the 12th Parliament. So let's see. On 21st September 2020, former Chief Justice David Kenani Maraga issued an advisory to then President Uhuru Kenyatta recommending dissolution of the 12th Parliament for its failure to enact the legislation required to implement the 2/3 gender rule. The advisory described Parliament's inaction as evidence of lackadaisical attitude and conduct over more than 9 years. As a result, multiple constitutional petitions were filed challenging Parliament's failure and seeking implementation of the rule. So, legal proceedings. Several petitions were filed, including by Margaret Toili and others, petition that and related matters. These petitions sought resolution of Parliament for non-compliance with Articles 27(3), 81(b) and 100 of the Constitution and the adoption of the Maraga advisory. An application was made to consolidate these petitions. The Toili ruling addresses consolidation issues across 12 and 13 Parliament sessions. A court subsequently squashed the Maraga advisory as unconstitutional, holding that the power to recommend resolution by advisory is not a standalone constitutional power of the Chief Justice. These raised critical issues of separation of powers and the judicial overreach versus judicial enforcement of constitutional obligations. So they cited separation of powers. They cited that Maraga had contravened the separation of powers, that it was a judicial overreach. And let's see now the key legal issues in that case. In the Toili now, because now this is the Toili case that was decided, that was filed as a petition pursuant to the Maraga advisory. Separation of powers. Courts distinguished between enforcing constitutional obligations through judicial proceedings, legitimate, and using informal advisory mechanism to direct the executive to dissolve parliament constitutionally impermissible as a standalone CJ power. So, court may distinguish between enforcement of constitutional obligations through judicial proceedings and using informal advisory mechanism. So for this one, the court stated that Maraga used an informal advisory mechanism to direct the executive to dissolve parliament. You see, the message is home. The message is home. That the courts are only limited to enforcement of constitutional obligation, but they cannot direct the restructuring of another arm of government. Except now, but there are now exceptions. Also, this read it together with other cases like mutable, structural interdicts, the supervisory powers of the High Court and such. And not only the High Court, but let's just say courts, the supervisory powers of courts or courts with original jurisdiction. So please read this alongside other case laws like mutable, so that you don't just rely on this one alone, on this case alone. Because if you rely on this case alone, then the mutable case, then in the part of structural interdicts and powers of the courts, read that so that you distinguish between this specific case scenario and the others. Parliament's continuing obligation or question of the advisory does not relieve Parliament of its duty under Articles 27.3, 81B, and 100. The application subsists. So what we have understood is that there is still an obligation to Parliament of its duty under these three articles. But what has been quashed is the advisory by Maraga, because it's constitutionally impermissible. The Constitution does not permit Maraga to inform or advise the president to dissolve parliament. So that's another thing. Even if the court notes that what Maraga was directing, it is legitimate. There is a legitimate constitutional obligation on parliament. But this legitimate constitutional obligation on parliament cannot be directed, cannot be given as a directive or as an order to executive because of separation of powers. Bangalore principles connection. Principle 1, independence requires judges to act within the constitutional mandate. Principle 2, impartiality. Principle 6, competence and diligence. The advisory raises whether CJ Maraga acted within or outside proper judicial function. Senate versus this other case here. Senate versus Speaker of National Assembly, Supreme Court judgment of 2025. Addresses bicameralism, the role of the Senate and the separation of powers between the two houses. It is relevant to the broader gender rule implementation debate. So we are now in issue 7, that is Kenya's Artificial Intelligence Bill and the Starlink connectivity. So Kenya Artificial Intelligence Bill and the Starlink in here, SpaceX, the SpaceX internet, the one that they are saying that you don't need to have a dish, or you don't need to have a server in a geographical location. The servers for this internet connectivity, they will use satellites, so that if SpaceX is hosting the internet in the USA, they just ensure that they host that with the satellite, so that if you're in Kenya, you just connect directly without having to have import. Okay, what Elon Musk is doing, they are trying to delocalize they're trying to delocalize internet. Because remember, internet inaingia Kenya through cables, deep sea cables, fiber optic cables. There are fiber optic cables connecting the whole globe. From Africa to North America to South America, there are deep sea cables. So what Starlink is doing now, they are trying to revert internet to satellites instead of deep sea cables. So Kenya Artificial Intelligence Bill 2026, the proposed Artificial Intelligence Bill 2026 seeks to regulate the development, deployment, and use of AI systems across all sectors. There's this Lawyers Hub that we found on YouTube to the Lawyers Hub and Patrick J. McGovern Foundation hosted an AI policy dialogue on 26 March 2026 to discuss the bill's implications for governance, access to justice, and professional practice. Advocates disclosure obligation. In professional ethics, lawyers are required to inform clients when AI has been used in their matter, disclose the scope of use, identify the type of AI used. This draws on the CIAB guidelines in the use of AI in arbitration 2025. Key ethical risk, client confidentiality and data protection where client information is inputted into AI systems, accuracy and reliability of AI-generated legal research and drafting, liability where AI output is erroneous or misleading, conflict of interest arising from AI tool selection, anti-money laundering and know your client obligations or intersection. AI tools used by advocates must not compromise know your client obligations under Section 4 of the Law Society of Kenya Act and the Legal Profession Anti-Money Laundering, Counterfeiting, the Financing of Terrorism and Proliferation Financing Framework 2025. Client due diligence remains a personal professional obligation that cannot be delegated into an automated system. And of course, the Data Protection Act 2019. This Data Protection Act in Section 25, which is the right of a data subject, rights of a data subject. All processing of client data through AI systems must comply with the Data Protection Act 2019. Consent, purpose, limitation, and data minimization principles apply. Also remember there is an obligation to register with the office. If you are a data processor, you register with the Office of Data Protection Commission, ODPC. It's called ODPC. You either register as a data controller. I have actually made one of these applications. So when you're making this application, you say whether you are applying as a data controller or a data processor. I have an application actually pending for ODPC for a data processor. So you disclose you're either data controller or processor. Even if you apply as a data processor, you can always change that later to a data controller if you find that the type of data you're processing is that of control of data. So the difference between a data controller and a data processor is this. A data processor is one who gets data from a source and computes that data to come to a certain conclusion or to complete a certain task. But a data controller is one who collects the data in the first instance. So the data controller is the one who collects in first instance. So you collect data, collect in the first instance. So for example, a data controller is for example like let's say Safaricom. Safaricom is a data controller because when they're collecting any data on a customer, they are collecting it in the first instance. But now a data processor would be, for example, a court. So, for example, a court of law wants to seek, or an advocate who is engaged in a matter in court wants to seek some data from Safaricom regarding calls or M-Pesa transactions or such. Then they are a data processor. They are now processing data because they're not collecting it in the first instance. They're just taking the data to compute it to a certain conclusion. Yes. So let's go to Starlink and access to justice. Airtel Africa and SpaceX successfully conducted data and messaging trials of Starlink Mobile in Kenya in March 2026, marking a significant step towards satellite to mobile connectivity across Airtel's 14 African markets. SpaceX Starlink constellation now exceeds 9,400 active satellites globally, with over 600 launched in the first quarter of 2026 alone. The access to justice implications are substantial. Satellite internet enables remote court appearances, electronic filing of documents, delivery of legal aid services in arid and semi-arid lands regions where terrestrial internet infrastructure is unavailable and unreliable. This directly engages Article 50 of the Constitution, the right to fair hearing, including access to courts and legal representations for persons in remote areas. So, as we had said, that Starlink, what they're doing is the hosting of the internet is in satellite to mobile. Satellite to mobile means the satellites that SpaceX has hosted in space will serve somebody in Beijing, China, at the same time serving somebody in Nairobi, Kenya, serving somebody in Brazil, serving somebody in Antarctica, serving somebody in Australia, across the globe. The difference with the different the other internet that you are receiving, you have to have a satellite dish in your geographical location. For example, for you to access Wi-Fi, you have to have a router. You have to be connected through a router, unaona, or cable. So the internet provider anaweka cable kwa street zinakuja all the way to your premises. So that's the advantage that Starlink is bringing. Legal practice management implication. Law firms must update their technology and data protection policies to govern the use of satellite-enabled remote working, video conference hearing, and AI assisted drafting to comply with the Data Protection Act 2019 and the NSK practice rules. So I also listed the case laws. Mtaziangalia. What I wanted to do was go back to issue 1. I had promised to go back to issue 1. Let me do that very fast. If you will allow me, members. Let me go back to issue 1. So we are going back to issue 1. Because, we were not clear on how we will handle it. So I have come up with another presentation. It's quite lengthy. Should we go through it, or should I send it to the group so that you read the Word document of this issue 1 on child offenders in the criminal justice system?
I believe you can just go through it.
Yes.
Because there is a previous session. If you listen to our previous session on criminal litigation paper that was done in April 2026, we discussed the ODPP Prosecutor's Guide kutoka juu hadi chini. So it is very important we have a look at the same in your presentation. Next tunaona saa sita naingia nini inaitwaje, commercial transaction, where we analyze the procedures directly.
Umesema
Nini hizo? ODPP? Yes, tumepitia yote kutoka juu hadi chini. Kutoka juu hadi chini yote.
Yeah. Then let me go through this very fast.
Okay.
Structure of this issue. So hiyo guide ya ODPP kwa YouTube.
Yes, iko in YouTube. Criminal litigation paper.
Okay.
2026.
Structure of the issue. This issue is divided into 3 parts. Part 1 sets out the established facts of the Utumishi girls prior in the court proceedings to date. The facts are drawn from court records and verified reporting, not comment on facts yet to be determined by court. That is without being prejudicial. Part 2 sets out the complete legal framework governing child offenders in Kenya's criminal justice system, drawn from statute, ODPP, prosecutors guide to children in the criminal justice system, and the binding case law. Part 3 represents the line of authority on specific dilemma of sentencing child offenders who transition to adulthood, the most examination relevant area of this issue. That's why I wanted us to go back to issue 1 because of this part. We did not cover it clearly, so I hope we will cover it in this page. The Utumishi matter is actively before the courts. No statement is made in this page about the guilt or innocence and blah blah blah. As in, we will not be prejudicial. The Utumishi Girls Academy fire. The incident on the night of 27 May 2026 at approximately 0100 hours, a fire broke out at the Ringera dormitory block at Utumishi Girls in Gilgil, Nakuru County. The dormitory housed 220 students at the time. 16 died. Post-mortem examination confirmed the primary cause of death was severe burns. 79 other students sustained injuries. Arrest and investigation. Following investigation that included CCTV footage analysis, witness interviews, and forensic examination, 8 and subsequently 9 from 3 students were arrested and identified as suspects. The DNA samples were taken from parents for identification of victims beyond recognition. The CCTV footage has been described as central to the prosecution's case. Court proceedings at the Naivasha Chief Magistrate Court. The 9 suspects were arraigned before the Chief Magistrate Abdul Kadir Lorot Ramadan at the Naivasha Law Courts on 2nd June 2026. The orders and directions made in camera proceedings. The Chief Magistrate directed that the proceedings be heard in camera and that no live coverage by media be permitted. This direction was made pursuant to the Section 220 of the Children's Act Cap 141. Laws of Kenya, which protects the identity and the privacy of child suspects throughout criminal proceedings. The full names and identities of the suspects have not been published. The prosecutions, I hope somebody will look for us this case. There's a case on this. The full names and identities of suspects who are minors being published. There's a case. Is that right, Victor?
Yes, even in the guidelines, it is prohibited to reveal the full names and identities.
Okay, you can also use that as an authority. I was just looking for an authority. That one is a sufficient. Okay. It's a sufficient authority on this. Prosecution's application. The prosecution sought a 30-day further detention order to enable investigators to complete the investigation, trace and interview witnesses to enable investigators to complete the investigation. Trace and interview witnesses who dispersed when the school closed and process CCTV and forensic evidence. The court's ruling on that June 2026, Chief Magistrate Lorot granted a 21-day detention order. Bail was refused. The grounds were charges murder and arson are serious offenses. The suspects and key witnesses are known to each other, creating a risk of interference with the witnesses if the suspects were released. The investigation was at a sensitive stage and the detention was ordered for the safety of the suspects themselves. That is true actually. The suspects are held at the Nakuru Children's Remand Home pending the next mention. Actually, where I usually stay in Nakuru, where I am in Nakuru, this remand home is just next here. It's around here. It's just like a children's home like any other. It's not like a prison. It's just like a children's home like any other. The next mention is for 24th June 2026 for directions on timelines, progress of investigations and further case management. The government response. The government announced a compensation of 200,000 per family of each deceased student. The government also ordered a national inspection and audit of all body schools. Bodies were to be released from Naivasha mortuary from 17th June 2026 following completion of DNA identification by the government chemist. Historical context, so you clear. Let's go now to the legal framework. This is the part in Yatuku cover in the first presentation, and that's why we have come back to this presentation. So under section 2 of the Children's Act Part 141, a child is any person who has not attained the age of 18 years. This the definition governs the application of the entire framework for child offenders in Kenya. In Kenya's criminal justice system, all 9 Utumishi suspects are from these students and are therefore presumed to be minors for the purposes of this framework. The age of criminal responsibility, Section 14 of the Penal Code provides for the following graduated framework for criminal responsibility. So there is a graduated framework such that a person under 8 years of age is not criminally responsible for any act or omission because they are presumed to be, what do we call them? Infants. Do we call them infants?
Yes.
I think it's just a presumption of infants. They are infants or toddlers. A person under 12 years of age is not criminally responsible unless it is proved that at the time of the act of omission, the child had capacity to know that the act ought not to be done. A male person under 12 years is presumed incapable of having carnal intent. That is also true because males adolescence starts at around 12 years. The practical minimum age of criminal responsibility in Kenya is therefore 8 years. From 3 students would be approximately 15 to 17 years old, well above the threshold of criminal responsibility. So this is an assumption we are making. We are just presuming. So I hope, because now the case has not been decided. Prosecutorial obligation, ADPP Prosecutor's Guide to Children 2020. The Office of the Director of Public Prosecutions has published a Prosecutor's Guide to Children in the Criminal Justice System, issued under authority of DPP Nordin Haji. The guide sets out mandatory obligations on prosecutors at every stage of proceedings involving child suspects. The following are particularly relevant to the Utumishi matter. The pre-charge stage. So the first thing is the age determination. The prosecutor must establish the age of the child at the earliest opportunity and ensure that the charge sheet indicates that the suspect is a child. See paragraph 22 to 27 of the guide. Where age cannot be established by birth certificate, the school reports or other documents are acceptable. If age remains uncertain, Section 143 of the Children's Act enables the court to determine age and any doubt must be resolved in favor of the child. Victor, kuna hii part yenye I'm in doubt.
Yes.
Hii part here where age cannot be established by birth certificate. Ama
Yes.
naweza kuwa nimewamislead.
No, once is established by birth certificate, kuna age assessment factors that come into play. Kuna other school documents that can be used as per the guidelines. So it can have a very detailed explanation to alternatives to establish the age of a minor.
You have the use of initials. The name and identity of the child must not appear in any public document. Only initials shall be used in the charge sheet and all related documents. In the guide, paragraph 21 and the section 76.5 of the Children's Act. Protection and care file. A protection and care file must be open to track the welfare of the child suspect through the proceedings, incorporating reports from the children officer and probation officer, probation and aftercare service. Paragraph 9 to 10. Decision to charge. The prosecution must apply both the evidential test, realistic prospect of conviction, and the public interest test, taking into account the best interest of the child and available alternatives to prosecution, including diversion. What is diversion, Victor?
Okay, diversion ina happen hapa. Once the prosecutor amepata there is a child, alafu this child tuseme the minor akona two decisions, either to charge or sasa hapa hakuna not to charge, hapa itakuwa diversion. Diversion in that you are looking at alternative means of nini sasa kumpeleka through custodial, maybe akili yake yuko mzuri, unaona. So the minors wako na hiyo priority from the DPP that they can be taken for diversion as compared to the normal diversion. You are diverting from the normal route of criminal charges. Akona hiyo but haizi ifanya kama hajachukua report from the children's officer. Is because it is this report from the children's officer that will inform kama mtoto anafaa kwenda diversion route. Yeah.
Okay. Good one. So I hope we are following This is the step-by-step process we were looking for. Then now we are at pre-trial stage. Legal representation. The prosecutor must make an application for the child to be provided with legal representation. A child cannot represent themselves in criminal proceedings. That is Guide 56 to 57, Article 52H of the Constitution, Section 77 of the Children's Act. So this is distinguished from an adult person. An adult person can elect to represent themselves, but a child cannot. Guardian, when a child has no choice of guardian available, the prosecutor must apply for the appointment of a guardian ad litem, paragraph 59 and section 79 of the Children's Act. Pre-trial detention as a last resort. Detention of a child pending trial must be measure of last resort. Used only where there are compelling reasons for the shortest possible time, and the child must not be detained for more than 24 hours without leave of the court. Paragraph 75 to 77, Article 53, 1F and I of the Constitution, Article 49, 1F of the Constitution. The Naivasha Court's 21-day detention order reflects this framework. The detention was opposed by the suspects but granted on compelling grounds of investigation, sensitivity, and witness safety, and also the safety of the suspects themselves. Separate detention. Children must be held separately from adults. The Nakuru Children's Remand Home is the appropriate facility. Guide is the paragraph. In the guide, paragraph 81 and Article 53, 1, F, 2 of the Constitution. Trial stage. In camera proceeding. The prosecution must make an application for the case to be heard in camera to protect the rights and privacy of the child. Paragraph 95, Section 76(5) of the Children's Act, Section 220 of the Children's Act. This has already been ordered in the Utumishi matter. So, in camera, what do we mean by in camera? That the proceedings are recorded.
No, in privacy. They are in privacy.
So, in camera means
in chambers. Yes.
Oh, I remember. But now when we say that, the day when they were arraigned, I saw them being brought into court wearing hoodies. Hata kama walikuwa wamejificha na hoodies, they were brought into court.
Yes, in fact, hata some children matters zikiwa in court, hii virtual court, the judge huwa anamalizia nazo za mwisho so that to enable akuwa amaliza zingine, alafu anaambia advocate to log out. Anasoma jina yako, Brand Madhi kindly log out. Anangojea mpaka utoke. So that anabaki na only parties wenye wako related to that case.
But what I'm saying is, I know that they were brought into court and wakakalishwa hapo kwa dock.
Yeah, it is allowed because now people wenye walibaki kwa court ni watu wako related na hiyo kesi.
Oh, because I remember the only recording ilikuwa available ni only when they were coming into court, but the proceedings are ziko. There's no way you will find this proceedings.
Yeah. You can't. Yeah, Mr. Chedu coming call.
Then priority hearing, the prosecutor must apply for priority hearing to ensure expeditious disposal. Paragraph 88 and the report of child offender rules in the schedule.
Yes. Excuse me.
Chedu coming on phone.
I have a question.
Okay.
Like now,
yes.
I do remember in the criminal litigation class, there's the lecturer had an issue with the way they not only the children covering their face, but you find sometimes even these proceedings where high-profile individuals are involved, you find people being masked and all that. So I don't know if does the guideline provide that someone should cover their face, because I'm assuming, suppose the magistrate wanted to see the face of the kids off the camera, but now they were covered like that. So how will you know that even the person before you is the accused or the name matches the person who is appearing before you?
It's a been divided. but ni kama akitaka kuona anawaingiza kwa chambers to see their faces, because once you reveal them, unajua people watu tu utajua who took that photo ikianza ku trend. So it is a very good precaution that pia yafai kuona, nafaa tu kusikia their voices. Yeah. Pia Ringera, ukimaliza kupresent, I have various collection of news articles. Nilikuwa nataka tu tupitie pia briefly ile tu nakuambia this and this and this, hivyo ziko mingi sana nimezikompa.
Okay, let me terminology. Conviction and sentence in relation to a child. The correct terms are finding of guilt and an order upon finding of guilt. I hope sometime I hope we shall take note of this on the terminology. That is something that I had not noted before. So it is a finding of guilt, a conviction, and an order upon finding of guilt or a sentence. We can't call it a conviction or a sentence. Sentencing options under section 191 now repealed. So hizo tulipitia hizo. I will also share these documents. So we go back to the sentencing dilemma so that we get to what Victor asked for us in the news articles. So the dilemma is the Kenya's statutory framework recognizes only two categories of offenders: child under 18 and adult. So the law does not in any nuanced manner distinguish the different developmental stages of children, particularly teenagers who are typically both in need of care and protection, but who may also pose a serious danger to society through deviant behavior. This creates an acute dilemma into scenarios. Scenario A, the offender is a minor under 18 at the time of the offense, but has turned 18 by the time of conviction or sentencing. Options A to K of the section 91 of the Children's Act 201, that is the repealed act, were designed for active child offenders. The offender can no longer be committed to a boarding institution or rehabilitation school, yet sentencing as a full adult ignores the minority at the time of the offense. The offender is scenario B. The offender is slightly below 18 at the time of the offense and the case is concluded or is still a minor. The maximum available institution sentence under section 191 is against the institution for not more than 3 years, which may be manifestly inadequate for a grave offense such as murder or manslaughter. The courts have been a consistent line of authority from 2013 to 2022 resolved both scenarios through section 191, treating it aggregatory to a proportionate custodial sentence. The solution is described as a provision 1, pending law reform, which the courts have repeatedly argued Parliament to undertake. So the courts are calling for a law reform. I want you to note that we are referring to section 191 of the repealed Children's Act, so that we don't. Yes. Then we have JKK vs Republic 2013. JKK was charged with murder, contrary to sections 203, 204 of the Penal Code. When first arraigned before the High Court at Meru, two separate judges recorded observations that he appeared approximately 17 years old. A court order was made directing age assessment at Meru District Hospital. That order was not carried out, a procedural failure by the prosecution. 4 years elapsed by the time of the appeal. JKK was approximately 21 years old. The Court of Appeal upheld the conviction and sentence. Now that is a finding of guilt. Now we have called it an order upon finding of guilt, not a sentence. But now in this one it is a sentence because he was already 21 years old. The court made the following holdings which now form foundational principles for this area. The first principle: a death sentence cannot be imposed on a person who was under 18 years of age at the time of committing the offense. Life imprisonment is equally excluded. These sentences are incompatible with the Children's Act 201 and with Article 53 of the Constitution. Section, then now we have the second principle. Once the offender has exceeded 18 years, he is not suitable to be subjected to any of the specific sentences under Section 181, which are designed to correct and rehabilitate a younger offender. However, Section 191, 1L, it's L, I think. In any other lawful manner remains available. So there's the option of court to give an order in any other lawful manner. Then that principle, the purposes of sentences under the Children's Act are to correct and rehabilitate, taking into account the overarching objective of preserving the life and best interest of the child. Life has been lost and the offender is not recalled, the offender cannot be released except before being helped to understand the consequences of his action.
Kuna application ya nani anaitwa nani Said Omar.
Only be achieved through
niliweka kwa file, let me send to you. Nimecombine na objection.
Not understating, and that understanding can only be achieved through a custodial sentence. So now that an adult is given a custodial sentence. So the order in this case, this is JKK versus Republic, which gave 3 principles that a death sentence cannot be imposed for an offense committed when you are under 18. Second principle, once an offender has exceeded 18, it's not suitable to be sentenced as per the Children's Act. Is now those are designed to correct and rehabilitate a young offender. Then the third principle, the sentences in the Children's Act, they are to correct and rehabilitate best interest of the child and such. But now for this one, he has to be made to understand through a custodial sentence. He must not be released into society before he has had time to reflect on his sins. Yes, you must answer for your sins. That's what is just said. Then the order was given, it is 12 years imprisonment, and that's it. Then we have DKC versus Republic. And I wonder, how do we know the name of this one? We do know the name of this one. Dennis Kirui Chariot. Why? Victor, let me ask. When you turn 18, can these initials be disclosed? And can now the public know what your full names?
I believe so. I believe no, you will not be protected.
For this case, this DKC versus Republic, his name is Dennis Kirui Chariot.
I believe you will not be subjected to the privileges of privacy once you have done it.
This case appears in project material. Sorry, that was my tool. DKC was 15 years old when he committed the offense of murder and had turned 20 by the time of sentencing. The trial court imposed life imprisonment. The Court of Appeal held that life imprisonment is antithetical to the Children's Act and violates the principle of the best interest of the child. A sentence of life imprisonment was not available for a child offender, regardless of the gravity of the offense. Applying Section 191 and the principles established in JKK Republic, the court held the best interest of the minor offender require both rehabilitation and accountability. An innocent life has been lost. The gravity of the offense demands that the offender be brought to bear the consequences of the omission and the error of the judgment through a custodial sentence. I hope you note this, that even though they are a child, if at any time they turn 18, they must be made to bear the consequences through a custodial sentence. That's what the court is saying in this case. Given the gravity of the offense and the current age of the applicant, not be released to society without serving a custodial sentence. So life imprisonment was subjected to 10 years imprisonment from the date of conviction. Now, this one, the versus Republic, it was at Court of Appeal. So the High Court that had charged him, the court that had given the sentence in the first time, it had given him life imprisonment. But now the Court of Appeal comes to say that when you look at the principles of JKK versus Republic, then it is not proper to give him life imprisonment because the offense was committed when he was still 15 years old. But he has already turned 18 and he must answer, he must bear the consequences of his act. You see? So the court gave him 12 years in prison to substitute the life imprisonment. DLK states DLK was charged and convicted the magistrate of two accounts of robbery with violence, sentenced to death. his High Court appeal was dismissed. His Court of Appeal was dismissed. He then filed a petition in the High Court under Article 56 and 22 of the Constitution, arguing he was a minor at the time of the offence and that both trial and sentence were irregular. It subsequently confirmed he was a minor when the offence was committed. The Sanguki J said the following important contribution to the jurisprudence. The lacuna articulated, Kenya statutory system envisages only two types of offenders: child offenders under 18 and adult offenders 18 and above. The scheme does not distinguish between the different developmental stages of children, teenagers, who may be both in need of education and danger to society. The statutory scheme stipulates that a child above 16 can only be held in a based institution for a maximum of 3 years. An option wholly inadequate for serious offences, including grave robbery. The call for law reform and the LMS call for reform to the criminal justice system to provide manuals that the scheme and solution pending reform is 91 of the Kingdom Act. Factors considered for quantum, number of participants, use of weapons, guns. There were a number of participants. There was the use of weapons, a gun, pangas, and clubs, two separate offences. The highway location posing particular threat to road users, sole mitigating factors for minority and being a first offender. The court gave an order for 12 years imprisonment on each count of robbery with violence to run consecutively from the date of original sentencing by section 181. So unlike G, the sentences run concurrently, DLK sentences run consecutively, reflecting multiple separate offences. So for consecutive means now he is going to be in prison for 24 years. That's right. Yes, be in prison for 24 years.
Yes.
Then now we have Republic with TWG. Now this is the one that is similar to the case for Utumishi. So TWG was charged with 10 counts of murder contrary to 203, 204 of the penal code arising from the fire at Kabanet Dormitory Moi Girls School, Nairobi, on the night of 1st and 2nd September 2017, in which 10 students were killed. She was in Form 1, 14 years old when the offense was committed. The prosecution called 42 witnesses after evaluating the evidence of classmates, mates, school administration, police officers, pathologists, fire agencies, and telecommunication providers. The court found that the subject had a case to answer in all 10 counts and placed her on her defense. The conviction. In December 16, 2021, the court found TWG guilty of 10 counts of manslaughter to Section 202 of together with Section 205 of the Penal Code. The court found that the prosecution had not proved malice aforethought. The essential mental element distinguishing murder, Section 203, from manslaughter, Section 202. Beyond reasonable doubt, the 10 counts of murder were accordingly reduced to manslaughter. By this date, TWG had attained 18 years of age. The court conducted a mitigation hearing on 10 February 2022, at which victim impact assessment were received from families of the 10 deceased students, and a pre-sentence report was filed by the probation officer. Oral statements were also given in court by the parents of the victims in count 2 and count 10. The court faced a central dilemma. TWG was 14 years old when the offense was committed and had turned 18 by the time of the time of conviction and sentencing. The question was whether she should be sentenced as a child or an adult. The court applied the following analytical framework. Step 1, the Children's Act governs death sentence and life imprisonment are excluded. Step 2, options A to K of the Children's Act. Remember, this case was decided before coming into force of the current Children's Act. None of the specific sentencing options under Section 191, 1A to K serve justice in these circumstances. The gravity of the offences, that is 10 lives lost, and the current age of the subject now allowed rendered all those options inadequate. Step 3, following JKK the Republic and DKC the Republic, court invoked Section 191 as the tool available to impose a proportionate custodial sentence. Sentencing objectives applied. The court applied the 6 objectives under paragraph 4 of the Judicial Sentencing Policy Guidelines 2016: multiplication, punish justly, deterrence, specific and general, rehabilitation, enhanced reform, TWG was enrolled at, you can see, TWG was enrolled at Technical University of Kenya pursuing counseling technology, or counseling psychology, restorative justice, address victims' needs, victim impact statements considered, community protection, prevent release without consequence, denunciation, communicate societal condemnation. Probation report. The probation report recommended a combination of custodial and custody sentences. The court noted the recommendation but confirmed that probation report is not binding on the court. The order: imprisonment for 5 years on each of the 10 counts of manslaughter to run concurrently with effect from 16 December 2021. The offense of manslaughter carries a maximum penalty of life imprisonment. The 5-year sentence reflects minority of the subject at the time of the offense, balance against the gravity of the offense. So that's it. Then what to expect. I also included a part 4 of what to expect.
So, yes. Yeah. True, true. Hiyo ni lazima. That's why we have allowed you to go into the details of it. Yeah. So, thank you. So, okay, from my end, let me project. Acha kwanza ni end the recording so that if